All right, this is the detention docket for the 323rd District Court. It is Friday, October 2nd, 2020. It is Gonzales Day, or the Battle of Gonzales Day. All right, so in compliance with the Texas Supreme Court Emergency Order number 25 related to the coronavirus, we are not conducting in-person proceedings, but we are conducting them remotely as possible, and we are using Zoom. In order to comply with Tarrant County Judge Glenn Whitley, we are closing the courtroom to the public. And in order to comply with the Texas Constitution, Article 1, Section 13, we are broadcasting these proceedings online on YouTube so the public can observe the court conducting its business. No person may record, copy, or publish any portion of these court proceedings. A violation of this order is punishable by contempt of up to 6 months in Tarrant County Jail and up to a $5,000 fine or both. All right, so we'll go ahead and start with Roger Jones with Mr. Adeniji. Here. All right, I guess Mr. Adler is the attorney of the day. Mr. Adler, are you here? Well, I didn't anticipate this.
Uh-oh.
All right, well, Ms. Mills, are you determined sentence? No, okay.
Yeah.
Let's go.
Judge, I'm here. I can handle it.
All right, Mr. Gladstone. All right, you're going to pinch hit for Mr. Adeniji and Mr. Adler.
Okay.
All right, Mr. Jones, I'm Judge Kim. This is a detention hearing. You've been here for 10 days. I need to decide whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. This is the aggravated deadly weapon murder case. Spending night at a friend's house, decided to rob mom's boyfriend, shot him while he's sleeping, and then ran, and then allegedly. And then I guess they had a warrant and searched your house. You're level 1 outstanding. You've been here for 158 days, and sorry it's taking so long. We are doing our best to move this case so you have some kind of resolution of this matter. I see your level 1 outstanding as of today. So I guess, Mr. Nava, why did he drop in level?
Your Honor, it doesn't say specifically why. There's nothing put in there, but he's been back and forth between 1.0 and 1A.
Okay, good. Well, I'm glad to see that he's behaving. That's certainly something that will be a factor in how your case is disposed of at the end. All right, Mr. Jones. So at this point, I'm going to go ahead and detain you. I feel like you're a danger to yourself and the community, and releasing you would put them in harm's way. So I'm going to go ahead and detain you. But thank you for being level 1.0. I appreciate you, sir. All right, Marion King. Mr. Gladstone, this is yours.
Yes, it is, Judge.
All right, Ms. McGonigal, are you here?
I am, Your Honor.
Okay, so it looks like Mr. Adler is in trial in a different court and not getting out. So do you want to go ahead and fill in for the attorney day spot?
That's fine, Your Honor.
You were last on the docket, so it just made sense.
That's okay.
All right. So, okay, Mr. King, this is a detention hearing. You've been here for 10 days. I need to decide whether to keep you here or to release you. If I keep you here, you see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. And if you give up the right, anything said cannot be used against you in any other court setting. Mr. King, you are almost 17 years old, and you started out when you just turned 14 with terroristic threat, burglary of a habitation, criminal trespass, possession of weed, burglary of a building, possession of weed, criminal trespass, and then you were picked up, see, at the time you were 15 years old, 14 years, yeah, I guess 14 years old for the burglary of a habitation, aggravated robbery, and the capital murder. This is the one with the apartments, right? Went in and then shot the homeowner in front of her child, allegedly. Okay. So, Mr. King, I know you've been here a long time. A lot of this has to do with the appeal that was granted. And so that we need to go back and do the hearing. Your hearing on the certification is set again for October 21st. All right, so we're just coming up in a couple of weeks. We'll have that hearing. I will see you. This is a capital murder case. and I'm very concerned about releasing you to the community. So I'm going to go ahead and detain you. All right. Thank you, Mr. King.
Thank you, Judge.
Thank you. Thank you, Mr. Gladstone.
Judge, will you need me for any other serious cases?
No, actually, I forgot it's detention hearing, so we don't have to worry about the levels.
Okay, sounds good. Have a good day, Judge.
Hey, have a good weekend, Mr. Gladstone. All right, Nathaniel Pena.
Right here, Your Honor.
All right. Let's see. I'm waiting for the video to come in.
Is it in yet?
I hear you. I just don't have a video feed yet.
I hit it. Let me try it again.
Okay. Oh, there we go.
Okay.
Thank you, sir. All right, Mr. Pena, I'm Judge Kim. This is a detention hearing. The law says when a child's brought to our facility, you have to see a judge within 2 days, and I have to decide whether to keep you or release you. If I keep you here, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. If you give up that right to be silent, nothing you say at a detention hearing can be used against you at any other type of court setting. All right, so Mr. Pena, you were turning 17 this month. All right. This all started when you were 12 years old with an assault case, and then you were 14 with, I guess, a contempt of court. Ed, did Bennicus ever hold a kid in contempt? You did? Good for him. All right. And then about 5 months later, you had interfering with an emergency call. You turn 15, you have an assault family violence, which you got probation for. And I guess that probation discharged. So in August of this year, picked up for possession of controlled substance, terroristic threat, tampering with evidence, all in August. So now, I guess we let you go. Ms. Blair, we let him go on electronic monitor?
Yes, Your Honor.
Okay, good. So now we have year 16. You're saying yesterday, police were dispatched to a robbery call at a business. They said a Hispanic male wearing a red hoodie, black pants, black ski mask, black shoes, and black rubber gloves, armed with a black handgun, entered the business, pointed the gun at the victim and demanded money. The victim complied, and the suspect then left the store and got into the passenger side of a white vehicle, which left. That's July 22nd. So on August 11th, Haltom City contacted Fort Worth PD. They said they identified the suspect and relayed the message that on August 7th, Richland Hills was dispatched to a home for a suspect with a gun. Officer located Nathaniel along with 5 other people who lived there. While on scene, the owners gave consent to search the house for the gun. They found a black backpack in the dryer that contained narcotics, clothing, and a black handgun. Haltom City detectives sent a photo of the clothing handgun to Fort Worth PD, which matched the clothing and handgun used in the robbery. So on August 20th, there's a search warrant for the phone, and they reviewed the data, and they found a message that was sent by Nathaniel to an Alexandra on July 27th saying, "Alem licks and stores and stoves I hit, all them people I scared." So they were sent days after the robbery. There's another message in June when someone asked Nathaniel, "When are we going?" He told the person not to text him on this phone. It's for calls only. Then Nathaniel told the person, "If it's about lick, call me on Snapchat only." So September 28th, warrant was issued. They found Nathaniel at the motel where he and his mom were living. So you were released on electronic monitor at a 10-day hearing. You've had no electronic monitor violations. But we give you a drug test and you're positive for weed.
Actually, Your Honor, that was from last time. They haven't drug tested him today yet, and I did call this morning.
Oh, why didn't he came in yesterday? Why didn't they drug test him yet? Do we know?
I don't know, but I did call this morning to remind them.
Okay. And you're set for adjudication dispo. So let's see. You're released on September 8th. All this happened back in August. All right, so Nathaniel, here's the thing. Normally, when a kid comes in on a warrant for an offense that happened before they were brought in on the previous offense, my attitude toward that is to release them because you haven't broken the law since. However, this is a little bit different because a gun was used. I absolutely have very little tolerance for any time a child has a gun. and almost zero tolerance when a child uses the gun. And that's just the way I am. Children should not have guns. That's my rule. And so I stick with it. So the problem now is, if this was another case of a criminal trespass or a weed or, a shoplifting, something like that, I'd let you go because I felt like you really didn't break the law. But now that apparently that you have access to a gun or willing to use a gun, that makes me think you're a danger to community. I'm going to go ahead and detain you. All right, thank you. All right. So, Jemiah Reese.
What's your last name? It's okay. Judge, who'd you call next? I'm sorry.
It's Reese. Jemiah Reese.
Don't have it.
Right here, Judge.
All right, thank you. All right, Ms. Reese, I'm Judge Kim. This is a detention hearing. When a child's brought to our facility, you have to see a judge within 2 days, and I have to decide whether to keep you or release you. If I keep you here, you have to see a judge every 10 days while you're here. Jemiah, you're almost 16 years old. And then this all started, you were 14 with a terroristic threat, a criminal trespass, and evading arrest. Did we give her a drug test when she came in?
Your Honor, one was not completed.
Okay, hold on. Not completed means she gave the sample and we didn't complete the test?
No, I don't believe a test was attempted, but I did try to call him a few times this morning to see if we could get one before the detention hearing.
Okay. All right. Like detention knows we're supposed to test them when they come back in, right?
Yes, sir.
Okay. All right, so let's see. According to the police were dispatched to a disturbance around 10 o'clock last night. Witnesses pointed to Jemiah, said she was involved in the fight. When they were investigating, an officer who knew Jemiah stood next to her. She made an unknown phone call on her cell and told another party to come back. The officer was concerned for the officer's safety since he knew Jemiah's associates and her sister were known to have firearms and participate in violent crimes. They told Jemiah to put the phone down, but she refused. So they removed the phone. She unsuccessfully attempted to grab the phone and began to yell. So the officers escorted her toward the patrol vehicle. She resisted by pulling away, throwing herself to the ground. She was charged for interfering with public duties. So the original call originated due to an unknown suspect entering the apartment and assaulting Jemiah's sister. Jemiah tried to defend her sister and retrieved a knife, but the suspect left the scene by the time Jemiah got outside. See, you were referred back in August by Arlington for criminal trespass and assault against the elderly or disabled. According to the police, in July, police were dispatched to a residence about kids going to a pool. When the police got there, the 3 kids already left. Officers met with witnesses. One witness said they thought that the juveniles broke the gate the day before and came back to swim. She witnessed the juveniles enter the pool. She grabbed the youngest, and the older 2 fled. The female returned and squared off with the victim. Jemiah pushed the victim to the ground, causing her to hit her elbow on the concrete, and all the kids left. So they got surveillance video, recognized Jemiah. At a police interview, Jemiah admitted she was swimming, and she said when the victim grabbed the other boy, she admitted she pushed the victim to the ground before fleeing. So, C, prescribed medicine for ADHD and mood disorders, compliant with medication. Mom here?
Yes, sir.
Yes,
All right, Mom, tell me about this fight. Do you know anything about it?
yes, we were actually, me and her were on the phone when the officer actually pulled up. She was on the phone with us, telling us where she was. She was on the phone when the altercation happened. And they called me to go pick up Jemiah, which we went and went to try to find out where she was because she didn't know what apartment's name. She was at a family member house. So I was trying to find the apartments, but didn't know the name of them. when I
Well,
got there.
So Mom, what it looks like to me is Jemiah did nothing wrong per se, other than when the police told her to put the phone down, she just wouldn't listen to the police.
Yeah, because I told her I need to find out where they're at.
And then when they tried to arrest her, she refused to be arrested.
Yeah, he took her phone from her and threw it, and then we didn't know, we had to find our way basically.
Right, I understand. But it seems like Jemiah really wasn't in trouble until she escalated. And made it
Yeah,
worse.
till she, yeah, basically.
Now, does she do this at home too? I mean,
No. She takes medicine.
Mom, I'm just going to ask you, let me finish my sentences, please.
Oh, yes.
Okay. Does she take a bad situation and just make it worse at home?
No.
You know, because I'm looking at her history with the pool, she took a bad situation, made it worse. You know, now with the police officer, she took a bad situation, made it worse. Even when people came and got in the fight where she was trying to defend her sister, she took a bad situation and made it worse, right? And you're telling me that otherwise at home, she doesn't do that? She doesn't escalate situations?
Because when she's at home, she's under my supervision, which she's been in the house until she's the only one knew where her sister was. So she got a ride to go pick up her sister.
Then
Because
let me ask you this. If she behaves around you and when she's not around you, she misbehaves, why do you let her out of your presence? She's only 16.
That's the point. She hardly ever goes anywhere. But when she does, this happens.
Okay. So that didn't answer my question though. My question is, if it happens when she leaves, why do you let her leave?
Well, this particular day, she went and got her sister because her sister has an appointment. She the only one knew where she was.
Okay. So again, if she only misbehaves when she leaves you, why do you let her leave you?
Her sister had an appointment and she was going to get her for me.
I don't think you understand what I'm saying. I know why she left that day.
Yeah.
What I'm saying, Mom, is it's very predictable that she makes a bad situation worse. Why did you even give her permission to go get her sister?
Yeah, I didn't know how else to go get her. I didn't know where she was.
So why didn't you go with her?
Because she was already at the park and with a ride.
Why was she there when you're not there?
At the park?
Yes.
She was playing basketball.
So if she gets in trouble when you're not around, then why do you let her go anywhere without you?
Before she wasn't taking her medicine, she started taking her medicine. That's what made me buy her the phone, because she started doing right and she started back taking her medicine after the incident at the pool situation. That's why she hasn't gotten in any more trouble. She's been in the house and she's been on the swim team, and she took a drug test with MHMR where she did her medicine like a couple of Fridays ago, and she was negative. So she's been doing well. That's why I let her go to the park with her brother. They both went. When he came back, I told him to come back. And she
Let's just stop. Mom, let's just stop. Okay, so here's the thing, Jemiah. Jemiah, did they ask you for a drug test?
Your Honor, I just got a email saying that they tried to give her one when she woke up, because she was processing. It was about 2 o'clock this morning, and it says that she wasn't able to provide a sample when they woke her up this morning.
Did she provide one this morning?
She was unable to provide one this morning whenever she woke up.
Okay. All right, Jemiah, well, here's the thing. You have until noon to provide a sample. If you don't provide a sample by then, we're going to go ahead and take a hair follicle test, and you'll have to wait for 2 weeks for the hair follicle test results to come back. All right. So I want to know about your drug test before I make a decision. So meanwhile, I'm going to go ahead and detain you. All right. So Matthew Sale.
Yes, sir. Yes, sir.
Yes, sir.
Hello, Mr. Sale. I'm Judge Kim. This is a detention. Well, this is not a detention hearing, kind of. All right. So this is a little bit different. Just to let you know, you are listed as a runaway from the state of Oklahoma. Okay. And you are also evidently looking at adult charges from the state of Oklahoma. Okay. Adult criminal charges. So there's two things I want to go over with you. One, let's handle the runaway portion first. You're considered a juvenile, and there's an agreement between the states. Okay, who's in the parent room? Who's in the,
It's his adopted mother
okay,
and another relative.
okay. Could y'all be quiet, please? Thank you. All right, so Mr. Sale.
Yes, sir.
All right, so let's handle the juvenile side first. You're listed as a runaway. There's a certain set of laws that all the states in the United States have come to an agreement as far as handling runaways. Okay, it's the same procedure every state you go, even though every state has different laws. We've all agreed on the same way to handle the runaway situation. And that is called the Interstate Compact. It's just an agreement. What it boils down to is that you're alleged to be a runaway from the state of Oklahoma. So there is a procedure in returning you back to Oklahoma, just like there was a runaway from the state of Texas to Oklahoma, or let's say to Louisiana. Louisiana has to follow the same rules. So my question for you is, you actually have two choices. One, you can agree to go ahead and return to Oklahoma, acknowledge that you are a runaway from that state, you belong in that state, and that you agree that Texas should release you to Oklahoma. Or the other option is for you to say, no, I don't want to go back to Oklahoma, and I would like to have a hearing on my return. Now, this hearing is not about whether it's good for you to go to Oklahoma. All the hearing would be is, are you in fact Matthew Wayne Sale, and are you in fact a runaway from Oklahoma, and did Oklahoma provide the correct paperwork for your return? As long as you're Matthew Sale, as long as you're a juvenile, and as long as the paperwork's correct, then we'll send you back. That's what the hearing's for. So do you understand what I've said so far?
Yes, sir.
All right. So here's a question. At this point, do you wish to voluntarily return to Oklahoma as a runaway, or would you rather have a hearing to contest the return?
I would like to have a hearing.
Sure, that's not a problem at all. Now, the second issue is, and it's kind of moot at this point, that you are evidently looking at adult criminal charges. In the state of Texas, you have to be 17 to face adult charges. Evidently in Oklahoma, it's younger than that. So we have received notice that there is a warrant for you from the state of Oklahoma for a adult felony offense. Now, there's an extradition process that's also through a different interstate compact. And what that means is that you do have a right to a hearing on the extradition. Now, what that hearing will be is going to be about whether you, in fact, are Matthew Sale, whether there is a warrant, in that whether you're Matthew Sale, there's a warrant. I used to do these all the time. Whether the governor's warrant is correct. Yeah, and that's it. So it's not about the probable cause, how they found you, how they arrested you, anything like that. This is simply just administrative to make sure, very much like the juvenile one, it's just a different set of paperwork. And so you're entitled to a hearing to contest that. If you'd like to contest that, I will appoint an attorney for you to contest that. Or you can voluntarily waive the extradition proceedings and voluntarily return to Oklahoma to face your adult Oklahoma charges. I do need to let you know that in Oklahoma, you're looking at from the District Court of Oklahoma County, assault and battery with a deadly weapon charge. And that's what you're looking at over there. So would you like to waive your formal extradition proceedings, or would you like to have a contested hearing on this?
I'd like to have a hearing.
Okay, great. So Tarrant County, normally a different judge does these extradition hearings. I'll ask to see if they want me to do it or if they want a different judge to do it. So you may have to go to the adult courts to handle the adult extradition hearing. I don't know. It's really up to the other judges what they want to do. So, but I will make sure that you're entitled to these hearings and you get these hearings. I'm going to go ahead and appoint counsel for you. Mr. Sale, Mr. Adler. Mr. Adler, are you comfortable with the Form 3 hearing? I think you just joined. That's why.
Sorry, Judge. Yeah, I'm here. Sorry.
Okay. Are you comfortable for a Form 3 contested interstate compact?
I am, Judge.
All right, Mr. Sale, this is Frank Adler. He is your attorney that was appointed to your case. And so he will be in touch with you as far as the Form 3 hearing for the juvenile runaway. As far as the adult extradition hearing, there's a different list of attorneys to get appointed those cases. When I was a private practice attorney, I was one of them. And so we can go ahead and I'll have an attorney appointed for you on that case as well. Okay?
Sir.
Any questions for me, Mr. Sale?
No, sir.
All right, thank you, sir.
Thank you, Judge.
Cynthia Spriggs.
I would like to speak with Mr. Adler.
Alexa says Andy Porter.
Yeah, it's, we'll have to go out here because they're fixing to start another hearing.
All right, Cynthia, I'm Judge Kim. This is a detention hearing. The law says this one is, oh, this is an attorney requested hearing. Ms. Mills, you requested this hearing.
Yes, Your Honor, when she was detained last time, she was supposed to get to level 1 and maintain it, which she has done. And you had said, I can't remember if it was you or Judge Porter that had it, but then she could have been released. However, we got a call, Ms. Turnerhill got a call yesterday from CPS saying that she could not return home because they were afraid of her being aggressive to other people in the home.
Okay.
So we just need to figure out.
Sure, no, I understand. So
Me
this, if
too.
I remember right, she was with a foster family, is that correct?
No,
Yes.
sir. She lives with her bio mom and grandmother.
Okay.
Yes, and CPS is on Miss Allen. Cynthia Allen is the assigned DFPS worker.
Okay, hello, Miss Allen.
Hi, how are you?
I'm well. When can you pick her up?
So the family just told me this morning that they are not able to find placement for her. So it's just a matter of doing a removal and finding placement. I'll have to contact OCOK to see if we can find placement today. If not today, possibly Monday.
Okay, so mom and grandma, you don't feel safe with Cynthia returning to you, correct?
We
No.
do. It's just CPS doesn't feel safe with her being around the kids.
So it's CPS's choice, decision,
Yes.
right? Okay, all right, so Miss Allen, this is gonna be really simple. Since mom and grandma are willing to take her home, she is showing behavior, so I'm willing to release her. Now, if you are saying you're not comfortable releasing, then you need to come and get her, all right? So y'all need to do the emergency removal today. What we're gonna do is tomorrow morning, well, actually, we'll do 5 o'clock today because tomorrow's a Saturday. Yeah, at this point, JPD, if 5 o'clock, I'm gonna sign a release to CPS, but if by 1700 hours they don't come and pick her up, then just release to the parents. Okay.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Oh, and I'm gonna release her on electronic monitor as well. Now, so here's the thing, who's the officer on this one?
I am, Your Honor.
Ms. Hall, okay. Oh, no, Ms. Turnerhill? All right, so Ms. Turnerhill, if she's released to the parents, electronic monitor, if she's released to the department, I don't want to hinder OCOK in their placements. And so, because they need to be able to move around as they feel appropriate. So if released to CPS, no monitor, but if released to mom and grandma, there is a monitor. Does that make sense?
Yes, sir.
Okay. All right, Ms. Allen, anything else? I mean, that should be sufficient. I mean, that's enough to do a removal. I mean, you should have everything. I just don't want her over the weekend. You know, as I've been saying, we're not an RTC. You know, we can't just hold her here because we don't want her to go somewhere else.
Right. Well, Miss Barbara Evans, who the home that they're living in, has told me that Cynthia is not welcome back at that home due to the concern. So I will work on getting some placement.
Okay, great. Thank you.
Thank you.
Thank you, Your Honor.
Thank you. All right, that will now at this point conclude my portion of the detention docket. I'm going to go and hand this over to Judge Porter, who outdid me today. I'm wearing a pink bow tie for October, Breast Cancer Awareness Month. He actually outdid me with the pink robe. So kudos to you, Judge Porter.
Thank you, Judge Kim. It is October and it is Breast Cancer Awareness Month. All right, Quentin Collier. You Mr. Collier?
Yes, sir.
Mr. Collier, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and Mr. Adeniji is here as your attorney. The court has previously determined that probable cause exists to believe that you engaged in delinquent conduct, and you were brought in on a violation of court order, directive to apprehend, and you're currently pending a motion to modify probation. Let's see. Is that correct, Ms. Hall?
Because of the two new offenses, we're required to file a probation violation. So he's pending the two new offenses of committing new offenses.
And he's level 1A as of this morning?
Yes, sir.
All right, Mr. Adeniji, what are your thoughts?
I thought, Your Honor, for the most part, it's been level 1 outstanding, and is that to drop twice to level 1, level 1. So I will be requesting the court to let him go home with electronic monitoring. And the reason I'm asking that, Judge, is because it's been 10 days and we still don't have a petition on those 2 new charges.
Mr. Adeniji, how long does the state have to file its petition on the 2 new charges?
Judge, I know they still have time to, I'm just saying, whilst they are making the decision to do that, I think if the mom is willing to proffer to the court of maximum support, then I'll be asking if the court will give him that chance.
Please.
Well, your argument is well taken, but he has not yet proven to the court that he's willing to abide by the rules. Namely, he's at level 1A in the back. He's been previously placed on probation. He's not yet established in my mind that if I were to release him, he'd obey the rules at home. So on that basis,
I'm familiar with the court's, sorry, Judge. I'm familiar with this court's practice, and I had that in mind that that might be a problem. But I'm just using the fact that we don't have a petition, maybe that will soften the court's usual policy.
Not today. But try again on Monday, and I may be soft on Monday. All right.
And hopefully level 1 outstanding by then for at least 3 days.
There we go.
Appreciate you, Judge.
All right. Mr. Collier?
Yes, Your Honor.
Not today. All right. You need to get to level 1-0. You need to hold it for me, okay?
Yes, Your Honor. How long what would I need to hold it for?
I'm not gonna make that determination today. You just need to get there and hold it. All right? Because we've been through this before, like back in March, where you brought in detention and you were level 3 confined, and then you had to work your way up. So you know the rules. You just need to get there. At this point, I'm not going to give you a number. You got to get there and you got to prove to me. All right.
Leslie, don't let the judge recall those past instances. Don't do that.
Judge Porter has a long memory.
I know.
All right. Thank you, Mr. Collier.
Thank you, Judge.
Thank you, Mr. Adeniji. All right. Jeremy Hauser.
Yes, sir.
Are you Mr. Hauser?
Yes, sir, I am.
Mr. Hauser, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Mr. Daniels is your attorney. He's here. Mr. Hauser, did you meet Judge Kim at your last detention?
I did.
All right. What did he tell you about the levels in the back?
He just said that with good behavior, I could get out.
Okay. And what is considered good behavior in the back?
Outstanding.
Be more specific.
Oh, a 1 outstanding, I believe.
All right. What are you at?
I'm at a 2 outstanding because of the fact that
that wasn't my question. I didn't ask why. I just said what. Correct?
Yes.
What is your level?
2 outstanding.
All right. Are you there yet?
Your Honor.
Yes, sir.
I think there are some extenuating circumstances in Mr. Hauser's case. He is in the custody of the state CPS, and his CPS caseworker is here. He has been looking for a placement for him since he was initially brought into detention. And I did speak with him on the phone this morning, and he has found a foster placement that he doesn't know if he can keep if Jeremy is not released to him. And he said it was extremely hard to find that placement in the first place. And he is here. His name is Mr. Jamar Gorman.
All right. I'm looking for Mr. Gorman. Oh, okay. Mr. Gorman, what can you tell me?
Yes, Your Honor. So, we've been searching for a placement for Jeremy since, I believe it was September 1st. They've yet to find one. They finally found one yesterday. I actually spoke with them today. They are still on board as of right now to take Jeremy into the home. It will be a intense care home where there will be 2 respite providers who will be with Jeremy at all times. He will be going to public school. They're gonna attempt their best to provide a safe residence for Jeremy while he's still in care.
You understand my reticence on letting him go.
I do, Your Honor.
What is that?
That he will run again, and we'll be back in the exact same situation that we were in prior to him coming into the detention center.
Mm-hmm.
If not worse.
Mm-hmm. And he was brought here from the Dallas County Juvenile Detention Center, correct?
Correct.
And
I believe it may have been Leelot, the runaway place, rather than the detention center. I'm not too sure. I was told both by the police department that he was at Leelot, and then one that he was at the juvenile detention center.
Judge, he was originally brought to Leelot, but when they discovered that he did have an active warrant, that's when they transported him to the detention center.
Okay.
to the Dallas Detention Center?
Yes, sir.
And then that was on September 10th, correct?
Yes, Judge.
And then he was brought into our detention center 7 days later. Is that correct? On the 17th?
Your Honor, I believe he was recovered on the 16th of September, and the next day was transferred to Tarrant County.
So that would be a yes. The answer to my question is yes. Correct?
Yes.
Thank you. Okay, and so Mr. Miller, when he was brought in to the Tarrant County Juvenile Detention Center on the 17th, he was administered a drug test, correct?
Yes, Judge.
And what were the results of that drug test?
He was positive for THC.
So, and that was 7 days after he was at the Dallas County. His numbers are still high enough to test positive for THC.
Judge, I think it's a misdate on there. That's when the warrant was issued, was on the 10th. He wasn't picked up until the 16th, and then we picked him up the next day on the 17th.
Okay. Okay, because the detention hearing report indicates that on September 10th, youth was referred in custody by his probation officer, Kevin Miller. Youth was picked up at Dallas County Juvenile Detention Center and transported to JPD without incident. So you understand my confusion between what you're telling me now and what the detention hearing report says?
Yes, Judge.
So you're telling me the detention hearing report is incorrect, that the correct dates are September 16th that he was at Dallas County, and December 17th is when he was transported, not what's in the report.
Yes, Judge. It should have read that the DTA was issued on the 10th.
Well, if CPS is going to give him a chance, then let's try and make that work. Okay. All right. Mr. Hauser, you're lucky. You would normally not get to leave today.
Yes, sir.
You normally would stay here for another 10 days till you got to level 1.0 and maintained it, especially given your history of running away and assaulting people and testing positive for drugs when you get back. But CPS has found a place for you. They think they can help you. We'll see if we can make it work.
Yes.
All right, that'll be the order of the court.
Thank you, Your
Thank
Honor.
you, Your Honor.
Faith Henley.
Yes.
Are you Miss Henley?
Yes.
Miss Henley, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Taylor, is here to represent you. All right, Ms. Rodriguez, what brings Ms. Henley to court today?
Originally referred in custody on September the 4th for assault on a peace officer ×2 and assault bodily injury ×3. She's one of the youth that was at Perimeter Hospital and was assaulting staff, and then she was also assaulting the police. She was released from detention to San Marcos Treatment Center on September 9th on conditions of release, which include for her to complete San Marcos treatment successfully. On September 14th, mom reported that Faith ran away from San Marcos with 2 other girls. The next day, mom said that the police had found her. She had been gone for 7 hours and had returned her back to treatment. Faith and the other girl had met a guy at a gas station and went home with him. They took his phone and ran off. One of the other girls' moms was notified, and she called the police, and that's when the girls were taken back to the facility. San Marcos was willing to let Faith continue in their treatment center. A DTA was issued by the court due to fear that Faith would run again. Also, the parents wanted to place Faith in a more secure facility. So a DTA was issued. We picked her up and we brought her back on the 17th. Prior to picking her up, the nurse at the facility called mom to let her know that Faith was being combative, threatening staff, saying that she was going to leave. And she was going to run at the first chance she can get. She has been to several mental health facilities and has a couple of diagnoses. The family resides in Wise County. The DA filed on one of the assault of a peace officer cases. The other cases were supervisory cautioned. And the family would actually like our department to place Faith.
Does she have a parent or guardian here today?
Parents are on Zoom.
We're here.
All right. Ms. Taylor, what are your thoughts?
I don't know, Judge. I have not received a copy of the petition. What I received was notification on text share that a charge had been disposed. I guess that was a supervisory cautions. So at this point, we do not have a date for adjudication disposition, nor do I have a petition. Now, that may have been filed, but it's not been received in my office.
All right.
Family has indicated they have another child at home.
All right. Ms. Henley, based on your history of runaway, I believe that if I were to release you today, you would abscond from the jurisdiction of the court. So I'm going to order that you be detained. You're at level 1.0 now. So I need you to maintain level 1.0. That will help Ms. Taylor, your attorney, get the absolute possible best outcome for you. If you can get to level 1.0, and you have, and you can maintain that, then that will show to the court that you know how to follow the rules and that maybe, just maybe, you're willing to follow the rules at placement or detention or whatever. But that makes it much easier for your attorney to get the best possible outcome for you. Whereas if your behavior is horrible in the back, then you end up with a horrible outcome, and you don't want that, all right? All right, thank you. That's going to be the order of the court.
Thank you, Judge. May I be excused?
Yes, ma'am. Thank you, Ms. Taylor. Thank you, Mom and Dad. Martin Nicholas Herrera.
Sir.
All right, Mr. Herrera. My name's Judge Porter. We've met before. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. McGonigal, is here. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct. Martin, let me make this easy for you. What's your level in the back?
A3 confinement.
Uh-huh. What does it need to be before I can consider you to go home?
A 1-0, sir.
You're not anywhere close, are you?
No, sir.
What do I need to do?
I don't know, sir.
Yeah, you do. I have a choice of release or confine. Which one do I need to pick?
Confine.
Release or detain? Yeah, I order you be detained. Why do I have to order that you be detained?
Because I'm not a 1-0, sir.
Uh-huh. What's going on in the back that you can't get to level 1-0? What choices are you making that are preventing you from getting to 1-0?
Just not following instructions, sir.
Yeah, it's a little bit more than that, isn't it?
Yes, sir.
All right. What do you need to do to get to level 1-0? Make better choices, all right?
Yes, sir.
All right. Today I got to order.
Your Honor, the lawyer never called me back. Your Honor, this is his mom. From the last detention hearing, when you made the statement for the lawyer to call me, she's never called me, and I've left 5 messages.
All right, thank you.
I don't understand what this. Hello?
All right, thank you. Martin, you are ordered detained.
Yes, sir.
Why are y'all so rude? Oh my God.
All right, if the court coordinator will make me the host, please.
What do I need to do to talk to his lawyer? Do I have to file a complaint with the state of Texas? Can someone answer me?
Your Honor, good morning.
Good morning. How are you, Mr. Reyes?
I'm pretty good. How are you, sir?
Oh, better than I deserve.
Yes,
All
sir.
right.
So we have Martin Herrera, who I believe he's next.
No, he's already done.
Richard Vargas. I do apologize.
No problem.
Can you just give me a minute so I can go to the back and help with translation? I was asked to help her out.
No problem.
I'm on my way right now, Your Honor. Thanks.
Can you hear me?
Mute this until I'm ready. Okay, Your Honor, I'm ready.
Okay. Are you Mr. Vargas?
Es la señora Vargas. Yes.
Mr. Vargas, the law says when you're brought into detention,
Señora Vargas dice que la ley cuando el niño viene aquí al centro de detención,
and initially detained,
y es inicialmente detenido,
you must see a judge every 10 business days thereafter.
tiene que haber un juez cada 10 días y después.
Mr. Vargas, you have the right to remain silent.
La señora Vargas, ¿tiene usted el derecho de mantener el silencio?
You also have the right to an attorney.
También tiene el señor Vargas el niño de ser representado por un licenciado.
And is Mr. Adler here or is he gone again?
Está preguntando si está aquí licenciado.
I don't see him.
I don't see him, Your Honor.
Ms. McGonigal, are you available to help?
I am, Your Honor. As
Thank
long as I
you.
don't have to translate.
Okay. Mr. Vargas, I have appointed Kathleen McGonigal to be your attorney for this hearing.
El juez le está indicando a su niño que la señorita Kathleen lo va a representar como licenciada.
Do you understand?
Le estoy preguntando que se entiende.
All right. Okay. You are
Your
level
Honor, I'm
1.
covering for Officer Slayer.
Thank you. I was wondering. Okay. Let's see. Mr. Vargas was referred for the offense of assault causing bodily injury
A él lo detuvieron por una riña que tuvo
on September 18th, 2020.
18 de septiembre de este año.
He allegedly pushed his father and scratched his father.
Aparentemente empujó a su papá y lo rasguñó.
He has a previous referral for possession of controlled substance.
Él tiene un antecedente de posesión de sustancia ilegal.
Oh, this is the one with the 18 THC cartridges.
Dice que se está asombrando el juez de que él es el muchacho que tenía un cartucho con 18 balas.
Yeah. Okay. Mr. Zabek, how long has he been level 1-0 in the back?
He, as soon as he can get on level 1, he made it. So he's been on level 1 since the 21st of September.
Okay. Mom, do you want him to come home?
¿Quiere llevárselo a la casa? No, Your Honor.
Okay. Richard, you understand what's happening here, don't you?
Dice, señor Ricardo, tú sabes lo que está pasando aquí.
Because of everything that has happened over the last several months,
Porque lo último que ha pasado en los últimos meses.
you've broken the trust with your mom.
Has destruido la confianza con tu mamá.
You understand that?
¿Entiendes eso? Está preguntando él.
You need to work on rebuilding that trust with your mom.
Necesitas reconstruir la confianza con tu mamá.
Richard, do you talk to your parents on the telephone?
Hablas con
Yes,
tus
ma'am.
padres por
Sure.
teléfono. Él contesta que sí.
Mom, when you talk with Richard on the telephone,
Señora, ¿usted habla por teléfono con su hijo?
sí. How did those conversations go?
¿Cómo es la conversación con él?
Igual como siempre.
He's the same one. He's the same one as always.
Él nunca ha pedido disculpas.
He hasn't asked for forgiveness or anything else.
Él se queja todo de nosotros como si nosotros tuviéramos la culpa de lo que él anda haciendo.
He's always complaining to them, and he blames on the parents of the things that he does outside on the streets.
Richard, part of growing up is learning to accept responsibility for our mistakes and our actions. That's a hard lesson to learn. And you have a choice. You can learn it on your own, the easy way, or you can learn it the hard way. Right now, you're choosing the hard way. And the hard way has consequences. Some of those consequences, including remaining in detention. So that is your consequence today. That'll be the order of the court. Okay. These hearings have been broadcast live on YouTube and keeping with the spirit of the open courts provision of the Texas Constitution. However, Section 5408 of the Texas Family Code provides that when a child or children are under the age of 14, the hearings should be closed to the public unless the public's interest in participating and viewing those hearings outweighs the child's interest in his or her own privacy. No such showing has been made to the court at this time. So accordingly, pursuant to Section 5408 of the Texas Family Code, the remaining hearings will be closed to the public. I will be stopping the live stream.